Within Chapter 5, we will explore the legalities of contracts. Once completed with this module, you should be able to identify and describe the elements required for a valid contract, explain the authority to contract, describe the various defenses to contract formation, examine the remedies available if a contract is breached, describe the value and use of alternative dispute resolution mechanisms, explain the potential non-party rights in a contract, and explain the impact of contract law on fire and emergency services. The case study included within the textbook for this chapter involves a problem between an emergency services agency and an emergency vehicle manufacturer. In brief, delivery of the vehicle has been delayed numerous times, which has created a significant problem for the emergency services agency. Additionally, given these delays, some of the originally specified equipment is no longer available. The salesperson is offered to include some free upgrades on the vehicle to make up for the delays, but the company refuses to issue updated specifications for the vehicle. With this scenario in mind, consider the following questions. Because the original deadline has been waived twice, does that mean the updated deadline cannot be enforced? Does the deadline waiver impact the validity of the rest of the contract? Could the vendor be held liable for the cost of repairs to the existing vehicle scheduled to be replaced with the new vehicle, given the significant delays in the production and delivery of that new vehicle? What is the enforceability of the free upgrades promises made by the sales representative? Can the agency simply back out of the contract at this point? Of the damages suffered by the emergency services agency, which ones could potentially be recovered against the vendor if a lawsuit were pursued by the agency? Once completed with this module, you should be able to answer these questions and more as they relate to the principles of contract law. Without exaggeration, the average person enters into numerous contracts almost every day. Examples of such contracts include the routine purchasing of goods and services. Other contracts that may impact fire and emergency services also include agreements between agencies, as well as the employer-employee relationship itself, which is based predominantly upon tenets of contract law. Needless to say, contracts are fairly routine within fire and EMS. To begin this discussion on contracts, it is important to know what a contract is. Simply stated, a contract is a promise or set of promises between parties that is enforceable by law. Contracts can be expressed or implied, and they can be written or oral. There are also two basic types of contracts. Unilateral, which is when one party makes a promise and the other party performs some act, and bilateral, where both parties make a promise to do something at a later date. Contracts can be as flexible as necessary as determined by the parties to the contract. Contracts can be entire, which requires substantial performance of the entire contract to avoid a breach, or they can be divisible, where performance under the contract can be divided up into discrete and separate parts. The governing law of contracts comes from essentially two sources. Contracts for services, real estate, employment, and other intangible assets are commonly derived under the common law of contracts, while contracts for goods and tangible objects are governed by the Uniform Commercial Code, or UCC. It is not uncommon for various jurisdictions to have laws that govern specific types of transactions, such as the sale of real estate or securities. Despite these numerous types of contracts, the elements of formation for a contract are always the same. There must be an offer, acceptance of that offer, and some type of consideration, which is the stuff or subject matter of value denoted within the contract. The first step in forming a contract is for one party to make an offer to contract to another party. For an offer to be valid, there must have been an objective commitment, intent to enter into a contract. The offer must have definite terms, the offer must be communicated, and there must be a specific person or entity to whom the offer is made. Once a person or entity receives an offer, he, she, or it must then decide to accept the contract as offered, reject the contract, or propose different or additional terms to the offer, which is then considered a counteroffer. If the person or entity receiving the offer can accept the offer only by performing a specific act, the contract is considered to be a unilateral contract, as only one party is actually making a promise. The other party must act to solidify the contract. Inversely, if the person or entity receiving the offer can accept by making a promise of his, her, or its own, a bilateral contract is formed. In such a contract, acceptance can be either expressed or, in some cases, acceptance may be implied by the person's or entity's conduct. The third part of contract formation, after an offer and acceptance of that offer, is the presence or existence of consideration. Consideration is the stuff that holds the obligations of the parties between them. Essentially, the parties must do something for each other. This exchange of consideration can include money, goods, or services. A party may also assume a burden he, she, or it was not otherwise legally required to assume, or a party may agree to not do something that he, she, or it was otherwise legally entitled to do. If there is ever a dispute over whether or not there was adequate consideration within a contract, courts will look at whether or not there was a bargained for exchange within the contract, meaning that both parties incurred some type of legal detriment as part of negotiating and agreeing to the contract. A gift does not count as consideration, and discretionary conduct is also not considered to be adequate consideration for the formation of a contract, as any promise made in a contract must be binding or obligatory. Moral obligations or feelings cannot serve as consideration within a contract either. As we will see, there are times when parties to a contract believe a contract was formed, but it turns out that was not the case, typically because the contract lacked adequate consideration. If a party acted to his, her, or its detriment on the reasonable belief that a valid contract was formed, courts will sometimes use the doctrine of Promissory Estoppel to pretend there was a contract for the sake of avoiding injustice given a reasonable, detrimental, and foreseeable reliance upon the promise made within the invalid contract. If promissory estoppel is used by the courts, the relief granted is typically only the amount necessary to avoid the injustice associated with this reasonable, detrimental, and foreseeable reliance. Another element that comes into play in the creation and enforcement of contracts is the parole evidence rule. We mentioned briefly before that contracts can be either oral or written. An oral contract is just as enforceable as a written contract, but proving the existence of such an oral contract can be difficult given a dispute, as there is no written proof of the contract's existence. If the parties do indeed take the time to reduce their agreement to writing, the parole evidence rule prohibits one party from alleging that other terms should be a part of the written contract given an oral discussion related to that contract. If the parties thought the oral discussion was important enough, the discussed terms should have been included within the written contract. There is also something known as the statute of frauds that limits the enforceability of oral contracts in certain situations. In brief, any contract that cannot be completed within 1 year is for the sale of real property like land or a house, is for the sale of goods worth more than $500, involves marriage, or is a suretyship where one party promises to pay the debt of another, must be in writing. The statute of frauds will not recognize oral contracts as valid in these specific cases. Once a contract is formed, it is possible for the parties to modify the terms of the contract depending on the terms of the contract itself, along with the applicable laws within the jurisdiction. To modify a contract, all parties to the contract must mutually agree to the changes. If the contract was formed under the common law of contracts, there must be some type of additional consideration involved for the modification to be valid. Under the UCC, on the other hand, no additional consideration is required for a contract modification so long as the parties bargain for and agree to the modification. If a person or party wants to enter into a contract and makes an offer to another person or entity, there are ways to limit or rescind the offer depending on the circumstances. For example, the offer itself may specify a period of time after which the offer ends. A simple example is a merchant advertising a sale in the local paper that indicates the sale price is good until a specific date. Once that date passes, the offer to sell the product at that sale price is no longer valid. The person or entity making the offer may also rescind the offer if it has not yet been accepted. Using another sales example, maybe you stopped at a rummage sale, saw something you liked, and offered to pay a certain amount for the item. The seller says he needs to run it by his wife first, at which point you tell him to just forget it. You rescinded your offer to purchase before that offer was accepted. If the person receiving the offer rejects the offer, and that offer was made specifically to that individual, then the offer is then terminated. On the other hand, the person receiving the offer can accept it, which also terminates the offer, so to speak, as the offer transitions into a contract given that acceptance. Outside the intent of the parties, there are also some special circumstances that may terminate an offer without any affirmative action by the parties. Such special circumstances include the death or incapacity of the party making the offer, or the destruction of the object that constituted the contract's consideration. With this information in mind, there are also some offers that cannot be terminated. If a party considering acceptance pays the offeror for the option to contract at a later date, whatever that may be, the offeror cannot terminate that offer during that bargained for period of time. It is also not possible to terminate an offer on a unilateral contract once the work that constitutes the other party's acceptance has begun. One of the reasons we are discussing contracts is not because they are so pervasive within our society, but because there will invariably be a time when a contract, or a lack thereof, may be problematic for a fire department, EMS agency, or one of its employees. For this reason, it is important to understand what it takes to form a contract, and inversely, what types of things can invalidate or void an agreement. One such wrinkle to contract formation is whether or not the individual actually had the legal authority to enter into a contract. Generally speaking, the ability for an individual to enter into a contract is somewhat inherent for an adult. As a matter of fact, people enter into contracts all the time without even realizing it. Did you stop at the local coffee shop for something to drink this morning? If so, that purchase constituted a contractual relationship between you and the coffee shop. Essentially, anytime you buy something, a contract is formed. Where the authority to contract becomes a little more nebulous is when a legal entity, such as an association or a corporation, is involved in the contract. Remember from our discussions in an earlier chapter that legal entities such as corporations, associations, governmental agencies, and so on have the same rights as individual people in many cases, which includes the right to enter into contracts. If a large corporation or entity wants to enter into a contract, who exactly has the authority to bind that corporation or entity in contract? To address this question, many corporations and other legal entities have specific rules that dictate who can bind the entity in contract. Given such a policy or procedure, identified individuals are said to have actual authority to bind the legal entity in contract. A municipal fire department, for example, may follow purchasing and procurement procedures established by the municipality that stipulates only a budget manager may enter a contractual relationship with a vendor if the contract exceeds a certain dollar amount. In such a case, that budget manager has actual authority to enter into a contract on behalf of that entity. There is also something known as implied authority, where an employee or agent of an organization is assumed to possess the authority to conduct business on behalf of the entity, even if there is no formal document providing such authority. Maybe you are on a small volunteer fire department that manages a meager budget. If the agency lacks a specific procedure for entering into contracts, it is still probably fair to say the fire chief, or maybe the chair of the department's board of directors, would have implied authority to enter into contracts on behalf of the fire department. So, what happens if a party enters into a contract with another entity and reasonably believes the person representing that entity has authority to contract on behalf of that entity, even though that is not the case? That individual who appears to have authority to contract is acting with what is known as apparent authority, and the contract will usually be enforceable even though the agent did not have actual or implied authority, because the agent held him or herself out as an authorized agent of that entity. With that being said, the circumstances under which the other party to the contract believes the other person is operating with the authority to contract must be reasonable. That party must perform due diligence to ensure the legal entity's intent to contract is valid and the individual is actually authorized to bind the entity in a contract. In saying these types of agreements will typically be enforced given an agent who is not actually authorized to enter into a contract, courts use a mechanism known as quasi-contract to enforce such an agreement to prevent the unjust enrichment of one of the parties to that flawed agreement. If the suffering party, if you will, performed reasonable due diligence and voiding the disputed contract would unjustly enrich the other party, the court may recognize the contract as though it were validly created between the parties through the quasi-contract mechanism. Despite best efforts, good faith, or other intentions, there are times when a party to a contract does not want the contract to be enforceable. If that is the case, the party must attempt to demonstrate that a valid contract was never formed or that there is a legitimate and legally recognized reason for the terms of the contract to not be enforced. Even if a contract is considered valid, there are some reasons as to why a court may declare the contract void or voidable. A void contract is not enforceable by either party. A voidable contract is considered valid unless or until the victim so chooses to consider the contract void. I will elaborate more in just a little bit. As already mentioned, if one of the parties to a contract can show that the contract was not properly formed, then no contract technically existed and the supposed contract will be considered void and unenforceable against either party. Ways in which alleged contracts can be improperly formed include contracts that lack adequate consideration, contracts where the offer was revoked prior to acceptance, contracts where there was no acceptance, or contracts where some other element required for valid formation was missing. In such a case, the courts will treat the voided contract as if there never was a contract in the first place, and if anyone suffered damages or harm, the court will try to restore the parties to the positions they held prior to the alleged formation of the contract. We already discussed capacity in terms of consent to medical treatment in a previous presentation, and many of the same capacity concerns or issues can come into play when discussing contract formation. The most predominant capacity to contract issues arise from contracts involving minors or mentally infirm individuals. As far as minors are concerned, anyone under the age of majority, as defined by the laws in the state, lacks capacity to contract. This is the case even if the minor misrepresents his or her age, thus giving the other party the impression that he or she is at least 18 years of age, or whatever the age of majority is in the state. At this point, you may be saying, I thought you said we enter into contracts every day, especially when someone buys something at a store or fast food restaurant. Kids make these transactions all the time. How can that be if they lack capacity to contract? That is a good question that I will answer in just a moment. Before we get there, however, there is one last point to mention with regard to mental infirmity. If the other party did not know of the mental infirmity at the time of the contract's formation, the contract will typically not be considered voidable by the courts. In order for a contract with a mentally infirm person to be voidable, the other party commonly must have known about the infirmity at the time of contract formation. Now, coming back to the question about minors entering into contracts, just because a person lacks capacity to enter a contract does not automatically mean the contract is void. Rather, the contract is voidable, which means it may be voided at some future time by the party that lacked capacity. So long as the party that lacked capacity wants to enter into and maintain the terms of the contract, however, the contract is valid and binding. Additionally, many jurisdictions will not void a contract for necessaries that include food, clothing, and shelter due to public policy reasons. If the person who lacked capacity realized the benefit of the bargain and can no longer return the item that served as consideration for the contract, courts will usually require the voiding party to pay restitution or the fair market value of the good or service received. If the item can be returned but has lost value or requires repair, the courts may require the voiding party to pay for the lost value or the cost of repairs. How such things are treated by the courts depends on the jurisdiction and can also fluctuate given the circumstances of the case. Also, if the person lacking capacity seeks to void the contract, the entire contract must be voided in its entirety. The person does not have the option to just void the unfavorable parts of the contract and leave the remainder of the contract intact. Voiding a contract is an all-or-nothing ordeal in these cases. Lastly, if the minor reaches the age of majority and continues to function as though the contract is valid, it will no longer be voidable. To clarify, the only one who can void a contract that is voidable based upon a lack of capacity is the person deemed to have that lack of capacity. The other party with full capacity to contract may not seek to void the contract based upon the other party's lack of capacity. If fraud, misrepresentation, or deceit is a factor in a contract's formation, that may be grounds for voiding a contract as well. In this regard, there are two types of fraud commonly recognized by the courts. The first is fraud in execution, where a party signs an agreement that is radically different from what was represented, or if the party was not actually aware that he or she was signing a contract. The other type of fraud is fraud in inducement, where the victim knew he or she was entering into a contract but was deceived about the subject matter by the other party. To clarify, a failure of one party to read the agreement prior to signing does not constitute fraud, and such a failure to read a contract before signing does not invalidate the contract. From a consumer standpoint, think about a cell phone provider contract or the terms of use associated with an online music service like iTunes or something similar. Those contracts are crazy long with a lot of legal terms and proverbial fine print, and I would venture to guess that most consumers did not read those contracts before signing them. Such a practice can be costly, as such contracts are still valid and enforceable even if one party did not read the agreement in its entirety. Duress within the realm of contract formation, also referred to as force or undue influence, can occur in one of two ways. Personal duress is where a wrongful act or threat overcomes the free will of a person, resulting in what is essentially an unwanted contract. Economic duress occurs when a party to a contract takes advantage of the other party's bad economic situation. In either two occurrences, duress could be a valid defense to contract formation. While it should go without saying, a contract to perform an illegal act will typically not be upheld by the courts. Believe it or not, there are exceptions, however, based upon the type of illegality involved. First, if the subject matter of the contract itself is illegal, the contract is void, pure and simple. A couple examples would be a murder-for-hire agreement or the sale of illegal drugs. If you make a drug deal, pay the dealer, and the dealer sells you powdered sugar instead of the cocaine you were hoping for, taking that drug dealer to court will not help you, as the court will not enforce an illegal contract. The other type of illegality is if a party enters a contract for an illegal purpose. In such a situation, the subject matter of the contract itself may be completely legal, but the purpose of the agreement is to further an illegal activity. As an example, renting a van is not a problem. Renting a van to fill it with explosives, park it in front of a federal building, and blow up the building, on the other hand, is a very different thing. In such a case, the original agreement is still binding, but it becomes a voidable contract, voidable by the innocent party. There are occasionally cases where there is a mistake made by one or both parties, or there is some type of ambiguity in the contract. What happens in these situations depends on the specific scenario. As far as mistakes are concerned, a mutual mistake occurs when both parties make false common assumptions about a material issue in the contract. If that occurs, the contract will typically be voidable by either party. Say that your fire department enters into a contract to buy a used fire truck under the premise that the pump is capable of pumping 1,200 gallons per minute and the vehicle has a 1,000-gallon tank. Both you as a purchaser and the seller believe both of these provisions to be true, and the contract is signed. At some reasonable point afterward, however, it is determined that the information is not correct. The pump is actually rated for 1,250 gallons per minute, and the onboard water tank is half the size at 500 gallons. Is the pumping capacity a material issue? 50 gallons per minute one way or the other on a 1,200-gallon pump is probably not a big deal. A tank of 500 versus 1,000 gallons, on the other hand, could be very integral to the agreement and would probably have been a deal breaker for you or the seller. At that point, you and the vendor could still go ahead with the sale, or maybe you mutually agree to modify the terms of the agreement. On the other hand, maybe your fire department just wants to back out of the deal. If the mutual mistake regarding the tank capacity is a significant material issue in the contract, a court would more than likely allow you to void the contract given the mutual mistake. In comparison, a unilateral mistake occurs when only one party makes a mistake regarding any issue in the contract. If the other party knew or should have known about the mistake, courts will typically allow for a correction of the mistake by the non-mistaken party, so long as the result is not oppressive or would create a significant undue hardship for either party. Otherwise, the contract may very well be voidable by the mistaken party. If, on the other hand, the other party did not know of the mistake and it was not reasonable for that party to know about it, then the agreement will more than likely remain in force. You have heard the expression buyer beware? This is definitely one of those cases. The third type of mistake is not necessarily a mistake, rather it is an ambiguity within the contract. The contract has a term that could have more than one meaning. In such a scenario, what happens depends on the intent or knowledge of the parties. If the parties intended the ambiguous term to have the same meaning, or one party knew of the ambiguous term while the other did not, then the agreement will commonly be enforced, using the not knowing party's definition of the term if that is the case. If neither of those fact patterns apply, then the contract will more than likely be considered void. In the event of a contract that is horribly unfair or, in legal terms, unconscionable, the court has options. Initially, unconscionability began as a UCC defense. Over time, it has evolved to include virtually all contracts, including those not governed by the UCC. For this defense to succeed, however, it must be shown that the contract was unconscionable and that the terms were unfair or oppressive at the time of contract formation. If, after contract formation, something changes that makes what was once a fair contract into an unfair one, then that is too bad. The elements of this defense must be shown to have existed at the time of the contract's formation. There are two different types of unconscionability recognized by the courts: procedural and substantive unconscionability. Procedural unconscionability results between parties of significantly unequal bargaining power, where one party cannot hope to meet the other party at the same level. Substantive unconscionability looks more at the terms of the agreement itself, such as price, timeframes for performance, and other significant provisions of the agreement. If a court finds an agreement to be unconscionable, the court will typically try to modify or even remove the offending terms to make the contract objectively fair to all parties. On the other hand, if that cannot be achieved, the courts do have the ability to void the contract entirely. Somewhat related to the defense of unconscionability is the allegation that the contract is one of adhesion. A contract of adhesion is one that is so imbalanced in favor of one party over another that it would appear as though the disadvantaged party was not freely bargaining, or that no one in their right minds would otherwise agree to the terms of the agreement. In such a case, the disadvantaged party may not have had an option but to enter into the contract, and the superior party obviously took advantage of the circumstances and that inferior or weaker party. As with an unconscionable contract, the court may attempt to modify the contract to make it fair to the party that lacked the bargaining power necessary to avoid the agreement, or the court may simply void the contract as well. It is important to keep in mind that the threshold for unconscionability or a contract of adhesion is pretty high. These are not defenses that are easily made, as courts are not in the business of protecting people against bad decisions or entering into contracts that may not be in their best interest. Back in the day, for instance, charging excessive interest on a loan was considered usury. In some cases, charging interest at all was prohibited. Now it is not unheard of for credit card companies to charge 20% or even more on outstanding balances. What would have been considered unconscionable years ago is now common practice in today's financial world. If you recall earlier, we discussed the statute of frauds, which commonly requires contracts to be in writing if they are for the sale of real property, goods worth more than $500, cannot be completed within 1 year, and so on. If the statute of frauds applies and all conditions were not met, the resulting agreement will not be enforced by the courts. So, what happens if there is a legitimate legal contract in place and one party fails to comply with the terms of the contract? This failure to perform is called a breach of the contract. Given such a breach, if the non-breaching party waives a condition within the contract, then the party essentially gives up the right to seek redress or damages if the other party does not meet that condition. If there is no waiver, however, then the non-breaching party may sue for damages. It is also not always necessary for one party to wait for the other party to breach the contract before seeking relief by the courts. If a party indicates it will breach the contract before performance or a condition is due, the non-breaching party is reasonable to infer a breach at that time and has the option to either sue the other party right away or wait until the actual breach occurs. If the party decides to sue as soon as it knows the other party intends to breach the agreement, it does so based upon the legal doctrine of anticipatory repudiation. The non-breaching party reasonably anticipates that the other party will repudiate, breach the agreement. The law does not make the non-breaching party wait until the breach actually occurs in such a case, as doing so may actually make the situation much worse for the non-breaching party. There are some additional requirements that apply under the UCC if a party to a contract anticipates a repudiation, such as the requirement that the non-breaching party seek assurances from the other party first. If such assurances are not given, however, the non-breaching party must cease its performance under the contract immediately. It cannot wait until the breach actually occurs. Given an anticipated or actual breach in a contract, there are some unique situations in which the law may recognize a discharge of a contractual duty without penalizing the discharged party. These situations include impossibility, commercial impracticability, and frustration of purpose. If a contractual duty is discharged under the doctrine of impossibility, the court is essentially saying the expected performance is impossible. Over time, courts have expanded the threshold of what they consider to be impossible to include significant or extreme impracticability, which could also be grounds for discharging the duty. Under this doctrine, it is possible for an impossibility or impracticability to be temporary in nature, which will only freeze the discharge of duty until such time as the impossibility or impracticability passes. Say you have a contract with someone that requires unique personal services and that person suffers an injury that precludes the performance of those duties under the contract. So long as time is not a critical factor in the agreement, it may be possible for the court to allow the delay of that performance until such time as the individual is healed and able to once again perform under the contract. If such impossibility or impracticability is not temporary, however, the discharge of a contractual duty would be permanent. Similar to impossibility is commercial impracticability. This doctrine relates to extreme financial complications where foreseeability was an issue. As mentioned previously, the courts are not here to protect someone against a bad contractual bargain. If there is risk within an agreement, it is incumbent upon the parties to take that risk into account when the agreement is created. If, however, there are extreme circumstances that were difficult to impossible to foresee at the time the contract was formed that make the contract's provisions financially impossible to perform, the duty may very well be discharged by a court. Courts also recognize that there are times when the purpose or reason for a contract is upended by an external event that was not foreseen by the parties to the contract. In such a case, the contractual duties may be discharged given the application of the frustration of purpose doctrine. While we have tried to break contracts down into simple terms, contract law can be very complex, and the specific fact pattern associated with different scenarios can make a significant difference as to how the court will evaluate and interpret that contract. Additionally, if there is a breach of a contract and a party suffers some type of damages, the determination as to what those damages are or how they are calculated can be very complicated as well. To keep things simple at this level, if there is an issue with a contract, courts will typically try to place the parties in the position they would have held if the contract had been fully performed. If that is not possible, then the courts may try to restore the parties to the positions they held prior to the contract being formed. Sometimes parties to a contract will add a liquidated damages clause to the contract. These clauses are designed to define what damages will be paid by which party in the event of a breach. For such clauses to be enforced by the courts, it must be shown that, at the time of formation of the agreement, it would have been very difficult to ascertain what damages would be in the event of a breach, and that the amount of liquidated damages defined within the contract was a reasonable estimate of the potential loss. If the clause would result in a windfall recovery or a bonus for the non-breaching party, however, the courts will typically not enforce them, as such clauses cannot be used to penalize a breaching party. Depending on the contract and nature of the breach, there are scenarios where additional losses reasonably occur given the breach. These additional losses are called consequential damages. Other losses that would not have been foreseeable may also occur as well. These losses are called incidental damages. Both consequential and incidental damages may be awarded by a court in the event of a contract breach. Unlike tort law, however, punitive damages are not typically allowed in a contract breach case, even if the contract breach was intentional. If the subject matter of the contract was considered to be unique, such as real property or some type of unique item, the court may order specific performance and force the breaching party to complete his or her performance as required by the contract. If the contract involved the performance of some type of service, the court cannot force the individual to perform that service against his or her will. What the court can do in such a case, however, is prohibit the person from providing the same type of service for someone else during a specified period of time. An example would be a performer who backs out of a contract with one party to perform for a second party at the same time because the second party is offering him or her more money. If the court hears the case prior to the actual date of the performance, presumably through anticipatory repudiation, while the court cannot force the performer to perform for the first party, it can prohibit him or her from performing for the second party. We already discussed the doctrine of quasi-contract briefly previously when we looked at the authority of someone to enter into a contract and recognized that the court may enforce a contract even if the person entering into the contract did not have the authority to bind the entity he or she claimed to represent, given the reasonable appearance of apparent authority. There are other cases where a court may also use the doctrine of constructive contract to imply the existence of a contract where one did not actually exist to avoid the unjust enrichment of or an unfair result for one of the parties to a contract. This fictional contract is created by the court to provide equity between the parties and is known not only as constructive contract, but by the terms quasi-contract and implied in law contract as well. In evaluating a potential breach of a contract, courts may also recognize something called substantial performance in determining whether or not a breach actually occurred. Believe it or not, perfect performance is not always required by contracts, and close enough is good enough may be acceptable depending on the facts of the case. This is where substantial performance comes in. While express terms within a contract typically must be performed to their fullest extent, so to speak, other terms may be deemed met by the court so long as they are substantially performed. As a quick example, assume your fire department has a contract with a company to paint the interior of the fire station. The company painted everything but some unfinished areas and a couple stairwells. Your fire department refuses to pay because the entire station was not painted. The painting company, on the other hand, states that everything was painted except for these unfinished areas. Maybe there was ambiguity in the contract as to whether these areas were to be included or not. Regardless, given the large station and the fact that these two areas are very small in the entire scope of the full contract, the court may determine that the painter substantially performed and the fire department must pay in full as denoted in the contract. Again, unless denoted specifically within the contract, the threshold for performance is typically not perfect performance by the parties, but substantial performance by those same parties. When faced with a potential contract breach, especially given an anticipatory repudiation, the non-breaching party may not simply let the breach run amok in the hopes of incurring greater losses that can subsequently be recovered against the breaching party. The non-breaching party has a legal duty to mitigate damages that are caused by the breach. Stated another way, courts will not allow contract breaches to result in a windfall recovery to the non-breaching party, and the non-breaching party must make attempts to minimize the damages it suffers given the breach of contract. Say your EMS agency called a plumber to do some work, and that work was not performed well, resulting in a slow but steady water leak. Your service found out about the leak relatively early, but determined that the leak would impact an area of the station that it was hoping to remodel anyway. The thought was to allow the leak to proceed, thus damaging this other area so that, when the plumber is sued, he or she would be responsible not only for the cost of repairing the leak, but for the damages that resulted from the leak, including this area that will now need new drywall, carpeting, and other work. In such a case, the court would not allow the EMS agency to recover for all those damages because the EMS agency had the opportunity to mitigate its damages by turning off the water or calling another plumber in to fix the leak as soon as it was discovered. A refusal to mitigate damages and a subsequent court ruling that allowed such damages to be recovered against the plumber would result in a windfall recovery for the EMS agency, which is not permissible under contract law and the Mitigation of Damages doctrine. Unsurprisingly, contract disputes seem to occur all the time, but not all of these disputes wind up in court. In many cases, the parties are able to resolve the dispute between themselves with what is essentially another agreement. When that occurs, an accord and satisfaction is said to exist. The accord is the new agreement, and the satisfaction is the acceptance of the new agreement in lieu of the previous contract provisions. The previous contract provisions are deemed satisfied by the terms of the new agreement. Once an accord and satisfaction is reached, the unfulfilled provisions of the previous agreement are negated, and this new agreement is now controlling. A consumer negotiating a different interest rate on outstanding debt in lieu of simply not paying the debt or seeking bankruptcy protection is a quick example of an accord and satisfaction. Unfortunately, it is not always possible for the parties to a dispute to be able to resolve the dispute on their own. Rather than going to court, however, some contracts contain alternative dispute resolution language that requires mediation or arbitration by a third party for the settlement of disputes under the contract. Such contract provisions are commonly enforceable by the courts, and the courts will only step in if the results of such a process, binding arbitration predominantly, are arbitrary, capricious, or unconscionable. Mediation and arbitration are common mechanisms used within a collective bargaining agreement environment for not only dispute resolution, but for the process of developing a new collective bargaining agreement if the parties reach an impasse. We will discuss collective bargaining in a later chapter. As a collective bargaining agreement is indeed a contract, however, the applicability of mediation and arbitration to the creation and enforcement of such agreements is important to recognize. Of these two alternative dispute resolution mechanisms, the first is mediation. Within mediation, an external agent meets with the disputing parties to work collaboratively on a resolution. Again, this process is supposed to be collaborative, and the mediator is there to help the parties come together and reach an agreement. Mediation is somewhat lower stakes than arbitration, if you will, as a mediator has no authority to force a specific resolution, and proposed settlements are not binding on the parties, unless of course the parties ultimately agree on one of the proposed settlements and use it as the basis for an actual agreement. Arbitration, on the other hand, is different from mediation in that it is not necessarily a collaborative process, and if the arbitration is mandatory or binding, the decision will be applied against the parties. Arbitration is typically the next step in the alternative dispute resolution process after mediation if the parties are unable to reach a consensus or agreement on how to resolve their dispute through the mediation process. Within arbitration, an arbitrator or a panel of arbitrators will evaluate the evidence provided and will render a decision with which the parties must typically comply. The term typically is used because there is indeed something known as non-binding arbitration, which, as the name implies, is not binding on the parties. As mentioned before, mediation and arbitration come up routinely within emergency services related to collective bargaining agreements and will be discussed with some additional depth in a later chapter. If an arbitration process is considered to be binding against the parties, the arbitrator's award is enforceable and will be supported by the courts, unless the court determines the arbitrator's award was erroneous or unconscionable. People and entities can enter into contractual agreements for any number of reasons. While at its simplest a contract is an agreement between two separate parties, those parties can occasionally have the interest of other third parties in mind. How the law treats those contracts and what rights non-parties to a contract may have under the contract can vary significantly based upon the type of third party involved and the nature of the agreement. Many contracts contain clauses designed to benefit a third party who is not one of the original parties to the agreement. Such a third-party beneficiary is someone who benefits from a promise contained within a contract. For such a third party to have any rights under such an agreement, that third party must have been an intended recipient of the benefits defined within the agreement. That means the third party must have been identified within the appropriate contractual clause, the performance must run directly to the beneficiary, and there must be an intention to benefit the beneficiary. In such a case, if there is a breach of the contract, the third party can sue to enforce his or her benefits under the contract. Inversely, those beneficiaries who are incidental or unintended within a contract do not have any rights under that contract. To elaborate, consider a situation where a parent enters into a contract for the construction of a house for an adult son or daughter. While the contract is written between the home builder and the parent, the son or daughter is still the intended beneficiary to that contract. If something happens to the parent, the son or daughter still has rights under the contract. Some incidental or unintended beneficiaries of that contract may be the parent's grandchildren. Unless such grandchildren are specifically called out in the contract and the performance of the builder runs to them, those grandchildren do not have any rights under the contract as they are merely incidental beneficiaries to the contract. There is also a practice in the law that allows parties to a contract to freely assign their rights to other parties. Unless prohibited within the contract itself, any party to a contract may assign its rights to another party. In addition to certain rights within a contract, most parties to a contract also have specific duties that are owed as well. Unlike an assignment of rights, a party may not delegate its duties under a contract to another person or entity unless such an action was not prohibited by the agreement and the original party remains as a surety for the performance of the delegee. Needless to say, any third party indicated as an assignee or delegee must agree to such an assignment or delegation. In continuing our previous example with regard to the house building contract between a parent and a home builder, the home builder can assign its right to receive payment from the parent to a third party, and the parent simply makes payment to that indicated party to fulfill his or her obligations under the contract. On the flip side, the builder may not simply assign its duties or responsibilities under the contract to actually build the house to another home builder in order to skirt its responsibilities in the contract. If there is an issue and the parent needs to sue because of a breach, the original home builder is still responsible as a surety even if the breach was due to the actions or inactions of the delegee. So why have we spent so much time talking about contract law in a course geared for emergency service agencies? If it is not clear already, fire departments and EMS agencies are involved in contractual agreements and relationships all the time. Purchasing of equipment and supplies happen in compliance with applicable contract law. The purchasing of services, such as vehicle maintenance and repair, are covered by contracts. Even simple and routine purchases, like the on-duty crew buying food for the day, is governed by contract law. In a subsequent chapter, we will explore the employer-employee relationship with significant depth. That relationship is actually governed in many instances by contract law. Mutual aid agreements are also considered to be contracts. Needless to say, the business of providing emergency services is riddled with contracts. Some are simple, some are horribly complex, and all follow many of these rules that you just learned. That is why it is so important for fire and EMS leaders and managers to understand at least something about contracts and how they impact routine departmental or agency operations. Speaking of mutual aid agreements and their basis in contract law, such agreements are perfect for defining the respective roles and responsibilities of the mutual aid agencies before an emergency actually occurs. Rather than trying to figure out important logistics after a mutual aid event occurs, mutual aid agreements allow agencies to be forward-thinking and define important working provisions before an incident occurs. Such provisions may define when an agency may call another for help. What circumstances give rise to the need for mutual aid? If aid is summoned, how are the types and numbers of units dispatched determined by both agencies? Is there a cost to mutual aid? Who provides workers' compensation insurance coverage during the call? Who makes transport decisions if ambulances need to transport the sick or injured? If there is a legal claim that arises from the incident, who is responsible? Is there any indemnification language in the contract? And so on. Ultimately, there is great variety in how mutual aid is provided between agencies given the unique needs of those agencies, the areas they service, and applicable laws within their state. Such agreements can be even more interesting if they involve agencies across state lines where credentialing, certification, or licensure factors are involved. It is not only important for emergency service providers to know how to activate mutual aid when needed, but both agencies must have clear expectations of what type of help is available and what resources will be arriving, in terms of not only apparatus but people. Other logistical considerations should also be evaluated and addressed beforehand. Many areas rely on informal oral agreements or gentlemen's handshakes for such incidents, but continuing to rely on such practices may be asking for trouble at some point. Mutual aid agreements are just one more type of contract that could prove invaluable to a fire department or EMS agency. In closing, let's review some of the key points from this chapter. To begin, a contract is a promise or set of promises between parties that is enforceable by law. Such contracts always require an offer, acceptance of that offer, and adequate consideration to be formed. Such offers to enter into a contract can terminate in numerous ways. If a contract is formed, intervening principles such as improper formation, lack of capacity, fraud, duress, illegality, mistake, or unconscionability can result in the contract being declared invalid, void, or voidable. If a party to a valid contract does not comply with the terms of the contract, the party fails to perform, a breach has occurred. In the event of a breach, the courts will typically attempt to place the parties in the position they would have been in if the contract had been fully performed. If that is not possible, however, the courts may try to return the parties to the positions they had before entering into the contract. In the event of such a breach, the non-breaching party has a duty to mitigate the damages caused by the breach. In the event of a disagreement arising out of a contractual relationship, there is always the option for the parties to resolve their disagreement with an accord and satisfaction. Absent such an occurrence, alternative dispute resolution mechanisms, such as mediation or arbitration, may be used by the parties to seek resolution of the dispute. The contract may actually require one of these dispute resolution mechanisms to be used in lieu of a lawsuit filed with a court. Some contracts recognize third-party beneficiaries who are intended to benefit under the terms of the agreement. While these intended beneficiaries probably have enforceable rights under such contracts, unintended beneficiaries do not. Lastly, fire departments and EMS agencies rely on contracts for their daily operations. Whether part of a purchasing process, the employer-employee relationship, managing mutual aid, or other such routine operations, contracts are an indispensable part of managing an emergency service agency. Looking ahead, our next chapter will transition from the legal basics we have discussed thus far to looking at specific laws and provisions that govern the delivery of emergency services, beginning with patient privacy and EMS care-related laws.